is about to go live, so I'm just going to wait for it to go live. Yep, and we are live on YouTube. So thank you so much for coming. Can everybody hear me?
Yes, I can hear you.
Oh, thank you so much, Abayomi. And thank you, everyone. But as I said, keep playing the music. We have to start because we are taking Mr. Abayomi's time. Okay, so we need to honor his time
I
as
was
well.
enjoying the music too, so if anyone prefers the music to me, I'm fine with that.
No. We don't prepare the music to you at all. So thank you so much, Mr. Bayami, for joining us today. Today we're going to be talking about employment law in the UK, knowing your rights and your responsibility. I know there's a general misconception that employment law solely relates to employees, when the fact is that employment law is actually about both the employer and the employee, so that they'll know where to stand and also to help dictate the relationship that both of them have got. So with your vast knowledge and everything, I know you've got years, up to about 30 years of experience in this field. So we are so honored to have you here today, because we know that if we're coming to your office to ask for these services, this is going to cost us a lot of money. So thank you so much for giving us part of your weekend. So I'm going to yield the mic to you. If you could introduce yourself, and I will just yield the mic to you now. Thank you.
Of course. No, thank you. It's an absolute pleasure and honor to be asked to help and to share knowledge and experience. So it's my pleasure. So my name is Abayemi Alamoru. I'm a solicitor here in the UK, born here in the UK, although you can probably tell by my name, Nigerian Yoruba parentage. But to some extent, I'm fake Niger because I've only been, 4 or 5 times to Nigeria. But I think I understand some of the cultural kind of dynamics of Nigeria. But I've been practicing as a solicitor in employment law for, it's 38 years, Sonia, 38 years. I started in 1986. And in that time, I've worked for trade unions. So I worked in trade union legal services for nearly 12 years, 13 years. I've worked in private practice, so for some big private firms and some smaller private firms. I worked for an employers federation, which was really interesting. But for the last nearly 20 years, 18 years, I've been working for my own organization, my own business, with a partner of mine, and we've been going now for about 18 years and doing employment law for mainly large companies, but I've always kept a personal practice to help individuals, which Sonia you'll know about as well, of course. So I do still help individuals to address issues with their employers, but I do that more on a personal level when I've got the time and the opportunity. So that's me. I've been a business owner, I've been a solicitor on both sides of the fence. So I was really pleased that Sonia asked me to come along today, because what I would say is that employment in the UK and employment relationships in the UK have become ever more complicated and multi-layered. So what I want to try and do today, as Sonia indicated, is give you a sense of what an employment relationship is about in the UK, because it is quite different from many other economies, and certainly it's different from the Nigerian, African economy. It's even different from the North American economy. It's different from the Asian economy. The only similarities really are some of the old colonial lands of Australia and Canada. They've got the same basic employment law principles. But other than that, the UK is an employment law minefield to some extent. So let me try and give you an overview of the rights and responsibilities and the structure. And then what I'm happy to do is open up to questions, any questions about any kind of general issues or any specific issues. So yeah, you do get the opportunity of a bit of free advice if you want it. Okay.
Thank you so much. Thank you.
Okay, so employment in the UK, it's the key thing that I always get people to appreciate is it's a business relationship, but with also some social responsibilities. And that's managed by a body of rights and responsibilities that both sides, the employee and the employer, have to live by. So a business relationship which has a social element. So for instance, when we talk about the rights which come as a business, your employer has the right to require you to turn up for work, require you to turn up for work on time, require you to behave in a way which is consistent with the way that they expect, and also they can ask you to carry out your duties as directed by your manager. So that's what your employer basically will be asking of you. From your side, your right is to be paid for doing that. So if you turn up and you turn up on time and you work according to what you have signed up for, the job you have signed up for, then you've got a right to be paid. You also have rights in terms of your expectations and your employer to protect you from the harm of discrimination, to protect your health and safety, to ensure that you have the social convenience of holidays and things like that. So there's a swapping of rights and responsibilities, okay? It's really important to appreciate that. So yes, of course, whilst you can demand things of your employer, they can also demand things of you, and I've just outlined the basics. All of those things will be part of what we call your terms and conditions of employment. It's almost like a contract. In fact, it is really a contract. And some of you may be sitting there thinking, well, hold on a second, I haven't had a contract. I've not had a piece of paper that says on the top of it, contract of employment for Debola. I've never seen that piece of paper. It doesn't matter, because even if you've not got something down in writing, there can still be a contract of employment. There can still be terms and conditions of employment, because you naturally, when you enter an employment relationship, enter into terms and conditions. So the minute you say, yes, I'll take the job, and your employer says, well, turn up for 9 o'clock on Monday morning, that's a contract, that's an agreement. It's a formal agreement, even if you don't write it down. So the centerpiece of the employment relationship is the contract of employment. But it doesn't end there. Your organization, the organization that you work for, and some of you may work in, say, the NHS or for private companies, your organization, your employer will have policies and procedures They'll have a disciplinary policy, which will set out the rules that every employee must follow. There'll be what might be called a dignity at work procedure or a bullying and harassment procedure, which gives you the right to complain if you're being mistreated. There might be policies on hygiene, on how you must present yourself for work. So every company, every organization will have its body of employment law, employment relationship policies. And it's important that you understand where they are, because when you need to answer questions and when you need to understand things about what's happening to your employment, one of your first port of calls should be the policies and procedures that are relevant to whatever's going on in your relationship at that time. Okay. And as well as those policies giving you rights, the policies also put responsibilities on you. Like I say, the disciplinary policy will have the disciplinary rules that you have to live by. So it might say that lateness is a disciplinary issue and therefore you can receive a warning. It might say that misusing the computer is a disciplinary issue if you use the computer for private business. So the rules that you have to live by will be set out usually in a policy, and probably it will be the disciplinary policy. Okay. So far we've got the contract of employment, which sets out your basic terms and conditions, what job you do, when you're required to do it, and when and how much you're going to get paid for it. That's what's usually in the contract. Then you have policies and procedures, which will give you a sense of the internal rules and procedures that you can call upon during your employment. And then the third element of the relationship is legislation, law. So in the UK, again, unlike in many countries, the government has enacted, has put into place legislation which every employer and every employee is covered by. Okay. So for instance, one of the most common legal provisions that you might hear about, or two of the most common legal provisions, relate to unfair dismissal. So an employer has to have a good reason for dismissing you and has to treat you fairly if they want to dismiss you. And you have to ensure that you haven't done something which your employers can dismiss you for. So that's what unfair, for instance, the law of unfair dismissal is about. So every employer and employee is governed by that, whether you like it or not. You can't choose it, you can't opt out of it. That's what the government has said is in place. So we're all stuck by it. Okay. We have legislation on discrimination. You'll hear a lot about it nowadays. You'll hear a case where an employer has been taken to court, to an employment tribunal, for race discrimination, sex discrimination, homophobic discrimination, religious discrimination. All of those elements are protected by the law which has been introduced by various governments over the years. Again, not many countries have these legislative protections and legislative rights. If you go to America, there's no law of sex discrimination. There's no law of race discrimination.
Wow.
No, there isn't. There isn't. So the UK is different. It's a different structure. Yes, you can try and sue your employers for discrimination in the United States, but it's much more difficult because there isn't the same kind of legal structure that we have here. So there's a lot that goes in to an employment relationship in the UK, and it's really important that we appreciate that, because there is sometimes a perception that, as Sonia said, the only person that matters in the employment relationship is you. It's not. It's not. The law and the contract means that there are rights and responsibilities on both sides. Okay. The other thing, and I should say, if there's anything that you want to ask along the way, just unmute and feel free to ask me. You don't have to wait until the end if you've got any questions. Just one other element I'll mention in this kind of basics of the relationship before I move on to some cultural issues is, whilst most employment relationships are based on a contract of employment. So I begin working for the NHS today. I work full-time under a contract of employment, and I get a wage for turning up for work. That's being an employee. There are other types of relationship with the company that you carry out work for, which don't equate to a full employment relationship. So for instance, if I tomorrow go to the NHS and say, look, I'm a fantastic trainer, I provide management training, and I can train your managers to a high level, and then say, yeah, they say, well, we're interested in that. They don't have to give me a job on a wage. I can begin a relationship with the NHS in those circumstances, whether through an agency or maybe through offering services through my own personal consultancy. And in that kind of situation, I wouldn't be getting a wage. I'd be invoicing the organization, and they would be paying me for the work I do according to whatever deal we've struck. Now, some of you might be agency workers. Some of you may have been, may have joined an employment agency. I don't know, like Per Temps or Brook Street or somebody like that. And they may have then found work for you with a company. So that's the agency type of relationship. Or you personally, as I say, may have gone to a company and said, look, take me on, not as an employee, but I'll work for you and you pay me as you pay a consultant. There are many, many people who do it that way. Okay. And that gives a different body of rights. It actually reduces the amount of rights you have, because then the law treats you like you're in a relationship that's business to business and not business to employee. Employees have more rights than you do if you work for a company outside of a full employment relationship.
Right.
Okay. So that's the last element of the basics. I want to talk about culture next, because I think this is where, to some extent, it becomes most challenging. It becomes most challenging because this is all about how organizations, the company you work for, believes that people should treat each other. And that will be both a mixture of the legal position, but it will also be partly to do with the particular management in that organization and how they approach things and what expectations that they have. I'm going to give you a few examples, and some of you may have experienced things like this. And if you have, then you can tell us about it if you've got any questions or just good stories. So I talked about there being anti-discrimination legislation, and that's a key element, but that type of law has to be interpreted in the organization that you work for. So in day-to-day life, when you're having conversations with colleagues about things, you may wish to make comments which to you aren't offensive or aren't serious, or you are just trying to be popular. The best example I can use nowadays, and I was dealing with a case just last week, is on homosexuality and transgender. Okay, so if you have a 6-foot man, a 6'5" man standing in front of you, who, when he was born, was called Jonathan, but now he's saying that he wants you to call him Jane, and respect the fact that he's wearing a skirt, and that you should make sure that you call him her and not him, that type of thing. And you say to that individual, don't be silly, you're a 6'5" man, and I know that you were born John, so don't talk rubbish to me. We might think that's okay, and to some extent, in the world that we inhabit, in the environments that we've come from, it might be okay. But here in the UK, in the organization that you work in, that could be taken as something that's offensive, something that isn't consistent with the values and behaviors in the organization. It could be determined as an act of discrimination, and it could be something that results in a disciplinary issue. In the same way as if you've got a colleague at work who you like the look of, and you think, yeah, I'd like to perhaps develop a relationship with this person, so I'm going to approach them. That happens. We know that happens in life. We're all grown up. And then the individual, perhaps doesn't welcome your advances. You might want to try again, because you're determined and you don't want to be knocked back. If you make another approach, then again, in those circumstances, you might be putting yourself in trouble, because then, is that consistent with the way in which the company expects people to act? Is it consistent with discrimination legislation, not to sexually harass somebody? So there are all kinds of things that happen. Turning it the other way, it may well be that someone has said to you, as somebody from Africa or from abroad, as you're sitting at your desk, maybe with a packed lunch, and you've brought your ground rice or your egusi soup, and you're eating it there, and someone comes and says, ooh, that looks like snails, or something like that. Is that consistent with the expectation that your employer has of its employees? Is that potentially an act of discrimination for saying something to you which might be offensive to your culture? So these become the more difficult types of problem. Also from a cultural point of view, we all live lives. We all have our own lives to live. We all have children. We all have, or we may have parents here. It may be that we have difficulties with our landlords, or we might have second jobs, and balancing your life and work can become difficult. Maybe you're being asked to work when your children when you don't have any care for your children. So you have to face that challenge of, well, do I go to work or do I stay at home with my children? And you go to work instead, and then somebody finds that your children are at home alone. Those are problems which, in perhaps the society you came from, would be looked upon differently than they are here. And those kind of problems can have an impact on your relationship with your employer, particularly if it's an employer in the care sector. So if you work for the NHS or social services or in a care home, and your employer has employed you on the basis that you've put yourself as somebody who can care for people, and then you get, unfortunately, mixed up in some personal caring issue, your employer may ask questions of whether or not you remain a fit person to be a carer in their organization. So they're cultural issues and issues around the way in which your particular management in your particular organization look at things. So there are many pitfalls in employment relationships in the UK that come from the difference in how we are. I mean, like I said, I was born here, so perhaps even I don't have the understanding that some of you may have. You'll maybe tell your stories if you've had problems in that area. But as a solicitor doing this for, like I say, 38 years, I've seen these kinds of cases where I am representing an employer who has dismissed somebody because they left their children at home, work in a caring profession, and the employer says that they've lost confidence to continue to employ the individual, so they sack them. I've done many cases. I've done several cases like that. Okay. So that's the kind of cultural perspective and the values perspective in the employment.
Bayami, there is a question. There is
Yeah.
a question.
Mm-hmm.
It said, what age can a parent leave their child alone and go to work knowing that they can stay home safe by themselves? We've addressed this before in our last, I'm not sure this person was here. Is it possible for you to answer that, please? What is the legal age?
A child in the UK is anyone who is under 16. So technically, you cannot leave a 15-year-old at home alone. Technically, that's an offence. Yes, a lot of people do it, and perhaps in a cultural sense, the things that people do with children, certainly at that age, is inconsistent with the law. But because it's so prevalent, in most cases it won't be a problem. But you do hear, if you Google, mother leaves child at home and goes on holiday at 15, mother leaves 15-year-old child at home, you will see that mothers and parents have been imprisoned for leaving 15-year-old children at home. There have been. 16, like I say, is generally what is safe, and that's the legal. That's when childhood ends for these purposes, and adulthood begins at 16. Okay, so if you're leaving a child at home, certainly if you're leaving a child at home who is in primary school.
What about 12 and 15?
So it's the same. It's the same. So a child should not be left to cater for themselves, and a child is anyone under 16. So, but like I say, the culture gives more leeway, obviously, the nearer that children get to 16.
Yeah.
Okay, it gives more leeway, but you're not technically supposed to go to work and leave a 13 or 14-year-old at home. Now, like, I've been here all my life. I've got 3 daughters. Some you will know, they're all grown up. My youngest is 20 something, 29, I don't know. If you ask me, did I ever leave my children, did we ever leave our children at home when they were 13, 14? Yes, we did. Yes, we did. Did the neighbors tell on us? No, they didn't. If I saw my neighbors leaving a child at home at that age, would I tell on them? Well, no, I wouldn't. So that's why I say that there is a cultural norm and there is a legal requirement. The difficulty is in using your judgment to work out when it might become an issue. And what I would say is, generally, as a rule of thumb, you would be taking a risk because of snooping neighbors and people who are just nosy and like to get into other people's business. If they're seeing a child at home who is of primary school age, then the curtains might twitch and they might pick up the phone to social services. Certainly less so with a 13, 14 or 15-year-old, but technically it would be possible, but it doesn't really happen very often. Okay. So they're the kind of cultural issues that can affect your relationship with your employer and can affect, your potential to continue in a job. Okay. So what that tells us, that things can sometimes break down. You can have difficulties in the relationship. Like I say, there can be allegations made about you that become disciplinary offenses. You might have complaints about how your manager is treating you. You may be saying your manager's bullying you, your manager's giving you too much work, your manager's speaking to you in a way that's unacceptable. Alternatively, your manager might be saying that you're disrespectful. Well, you've got a loud voice and you're very emotional in the way that you come over. And therefore, those Nigerians or those Jamaicans, they're very aggressive. I can't tell you how many times I've heard that. So problems can arise in the relationship. So what do you do when things break down? Like I say, start with policy. What is it that your organization's policies say about the kind of problem that has arisen? Look at the policies. Can you get help? So this is a big thing. So if your employer has an issue with you and you want to defend yourself, you might want help. And you have limited ways in which you can be helped, because you don't have a right as an employer in the UK, as an employee in the UK, to bring in a lawyer when you've got an internal issue. Sonia, you and I know that. If you remember, we were involved in something where I helped you, but throughout that they don't have to listen to anything I say because I'm an external lawyer. Okay. So even if you've got the money to pay a lawyer, you don't have the right to bring that person into any dispute that arises with your employer. What the law says is that you have only an opportunity to bring in someone to help you if you're a member of a trade union. So you can bring somebody from that trade union to help you and to represent you. Or you can bring in a trusted colleague to help you. Okay. So I recommend to people generally that you join a trade union. and then you have an absolute right, if anything does happen, to use a representative from the trade union to help you. And whilst not every trade union representative is good, I worked for a trade union for 13 years, so I know that there are good and bad ones. I would rather have the option of being able to call upon a trade union than not. And it's well worth the money. Yes, you have to, pay an amount every week, maybe, I don't know,
Every month.
every
Yeah.
month, sorry.
Yeah. Just a quick question. So the trade union representative can come with you to those meetings internally, but the lawyers can't, right?
Absolutely.
Okay.
So if tomorrow your manager said, I'm bringing you on a disciplinary, Sonia, you've been late 12 times in the last 2 weeks, and you're potentially going to be given a warning, or we might even dismiss you. And you say, well, hold on a second, for that kind of meeting where I might lose my job, I want to go and get a good lawyer and prepared to pay whatever I need to keep my job. You cannot then say to your manager that a buy me is coming to the meeting with me. You have no right to bring a lawyer. The only right you have for a meeting like that is to bring a union representative or a colleague, so somebody else who works in that company that you trust to help you. So that could be someone who works in your team, it could be someone who works elsewhere in the organization, but they would have to be an employee in that organization. Other than that, you can't bring anyone else to help you.
That's when it gets really, really dangerous, because when you are in a hot boiling soup, nobody wants to be associated with you because they don't want to put their job in jeopardy, right? So most of the time, so it's just better to register with the trade union, to be honest.
Yeah, well, there's two things. First of all, colleagues might not be brave enough to step forward and help you, but also they may not have the skills and the knowledge to do so. Most employees just turn up for work to do their job. They don't turn up for work with the intention of representing somebody in a disciplinary issue. So even if you've got someone who you really trust and value as a colleague, whether or not they'd be any use to you in a disciplinary hearing is another matter altogether.
Yes.
But that's the law here. So that's that. If the issue becomes legal, so if you decide to bring some kind of case against the company, and if you're dismissed, or if you're discriminated against, or if you don't receive your full pay, then there is a legal process that you can go through to try to recover any loss or any disadvantage that you've suffered, and that's the employment tribunal. So in certain circumstances, depending on the nature of the case, also depending on how much service you have, for unfair dismissal, you need to be in employment for 2 years before you can even make a claim. But in any event, if you do bring an employment tribunal, then in no circumstances you would be able to use legal representation. But you'd probably have to pay or do a no-win, no-fee. So the solicitor would have to be confident that they would win some money for you so that you can pay them their fee out of your winnings. That's pretty standard nowadays in the UK. So yeah, things can sometimes break down because the fundamentals of the relationship are broken. Either you're not being paid, or because your employer thinks that you're not doing your work properly, or turning up for work enough, or turning up for work on time. Or you might say the employer's broken down because your employer isn't doing something that you expect of them, paying you the right money, or paying you sick pay, or they're trying to get you back into work when you're off sick, and for you that's unreasonable. So there are all kinds of issues that can happen in employment, and then we get to test some of the principles that I've kind of outlined to you today. So I hope that gives you a good flavor, and it's only a flavor because, like I say, there is so much employment legislation and rules and what have you, but they are the basics, the fundamentals. And if you've heard anything, or if there's anything on your mind that you want to ask about, feel free and I'll try and help.
Thank you so much, Abayomi. I really do appreciate your time today. Please, if you know you've benefited something from this session today, we need to really, really tell Mr. Abayomi thank you. And if you've got any questions, send it to me, or they're sending you thank you in the chat. Send me the questions, or if you want to just unmute and ask your question, please, now is the time to do so. But please put your hand up so we don't have two people talking at the same time. I have a question though. For example, when you come back when you do need flexible working, what is the best way to do that so that you have enough time to then pick your children from school, as in,
Okay. So there are legal provisions in the UK around flexible working. Also, your employer is likely to have some kind of flexible working policy. So the two things will probably work in harmony. But what's the basic right? Okay.
Yeah.
So anybody who has the responsibility for caring for a child, so somebody under 16, and is having difficulty coping with the hours that they're on or the days that they're working, can make a formal request for flexible working, a formal request for flexible working. So what does that mean? It means that you can put in writing what difficulties you're having with your current working pattern. You can then say what working pattern you would prefer. So for instance, I can't work between 8 o'clock in the morning and 10 o'clock in the morning. So you can say in your flexible working request, no work between 8 and 10 in the morning. The process that the law introduced says that you then have to say in the letter what impact you believe that will have on the work that you do. So for instance, you might say, I believe that not working between 8 and 10 will not be a problem because I've got 7 colleagues who work during that time, because the work can be evenly shared out between those times, and I will pick up work that they wish to redistribute between the hours of 3 o'clock and 4 o'clock or something like that. So that's the structure.
Okay.
What the law then says is that your employer your manager really would have to consider that request.
Right.
And your manager would have to fulfill that request unless there is a good reason for not doing so. And the law sets out 8 reasons why an employer might be able to reject a flexible working application. So it's quite technical, okay?
Yeah.
But what I'd say, and this doesn't just apply, and flexible working requests don't just apply to children nowadays. If you're caring for an adult, you can make a flexible working request, and the same principles apply. Okay. So if you've got care responsibilities for, a parent or a neighbor or what have you, you can make a flexible working request.
Okay. All right. Thank you very much, Abayomi. The questions are coming in. One said, what does it mean to be a zero contract employee?
So a 0 hours contract. Some people might say these things are evil, but they are legal. Unfortunately, there's been a lot of talk about outlawing them. But what's a 0 hours contract? So a 0 hours contract is where you're taken on by an employer, and it's typically the kind of thing that happens in retail. Okay, so Primark give you a job, and then you say, so what are my hours? And they say, you don't have any standard hours under this contract. What we can do is ask you to come in at any time to work. You can turn it down, but we'll ask you to come in any time. But we also have the right to not ask you to ever come in. So in other words, under that contract, there is no definitive agreement as to how many hours you're going to work, when you're going to work them, or indeed if you're ever going to work them. It's basically abuse by an employer who have got you dangling on the end of a string. It's the employer saying, when we need you, we'll call you. And these things cause all kind of difficulty, because on the face of it, they look great. I mean, for some people, they do work. They can, because it gives a certain amount of flexibility. But the problem is that the minute that you don't respond to a request to work, then you're in trouble. You're in trouble. The employer won't let you turn them down more than once, really, more than twice. They'll just stop asking. And of course, they've got no obligation to ask because it's a 0 hours contract. So it gets people into a real predicament, because often people end up working when they can't work. Because if you're asked to come in at 10 o'clock at night, and you say, I can't come in at 10 o'clock at night, that's when I'm caring for my children. And that's when, I'm trying to rest after, doing, some other stuff during the day. The minute you say you're not coming in on that occasion, they might not ask you again. So therefore, it puts your income in jeopardy.
Yeah. Wow.
That's what a 0 hours contract is.
Okay, I hope that helped who asked the question. Thank you so much. Someone said you spoke about contract being legal, where one is signed or not. Can you shed more light on this? When you said even if there is no written document, immediately you start the job, that there's a contract. Is applicable, yeah.
Yeah, so that's right. So ideally, every employer in this country would be organized enough at the very beginning of a relationship to give you a piece of paper which sets out all of the terms and conditions of your employment. There's actually a legal requirement to do so after 12 weeks, but still a lot of employers fail to do so. So a lot of people are working without ever having received a written contract of employment. So what some people then say is, and what some employers then try and say is, well, you don't really have a contract because there's nothing in writing. However, in reality, the contract began the day that you did anything for your employer that's consistent with a contract of employment. So if you turn up for work and work for 7 hours between 9 o'clock and 5, is that 8 hours? Between 9 and 5. So if you work for 8 hours a day for 2 weeks, 3 weeks. So if that becomes the norm, then you're effective, whether it's in writing or not, you're then in a contractual relationship where one of the requirements is to work between 9 and 5, because that's what you've been doing.
Yes.
In the same way, if you've been paid £500 a week because you've turned up 5 days a week and worked 8 hours a day, then even if you never signed anything, or you were never given a piece of paper to say that your wage is £500 a week, contractually, you would be entitled to £500 because by reference to what has happened in practice, even though it was never written down, the relationship has developed into one where you've worked 9 till 5 and been paid £500. So that in effect would be a contract of employment with those terms and conditions in it. If you were paid sick pay for a week that you were absent from work, then that would be evidence that you're also entitled to sick pay. So that if your employer, the next time you're off work, says, I'm not paying you sick pay, and there's nothing in writing that contractually says I have to, you can then challenge your employer and say, but hold on a second, every time I've been off in the past, you have paid me sick pay. So even if it's not in writing, I believe I'm contractually entitled to sick pay. So that's how sometimes you generate an employment contract, even though it was never set out in writing from the beginning.
Oh, I didn't even realize this. I hope that helps as well. Who asked the question? There's another question. Who is considered as being self-employed?
That may sound like a really simple question, but it's really, 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 just one more really, really complicated. And I don't want to get too technical, okay, but let me just give you an example. And it's a famous example. It's an example that you might all be familiar with without knowing the technicalities. Have you heard the phrase the gig economy? The gig economy. So doing jobs for organizations where they claim that you're not an employee and they claim that you're really a business person offering service to them. The most famous is Uber or Deliveroo, okay? All of those jobs in the past, because there's been a slight change, but all of those jobs in the past, the person who was picking you up in your Uber was not employed by Uber, because Uber said that the relationship with that individual was self-employed, because that individual provided their own vehicle, rented the system that goes into the vehicle, that gets them jobs, and the payment was based on each individual journey. So technically, when you pay your Uber, you pay it direct to Uber. You think you're paying, Mr. Islam, you're not. You're paying it direct to Uber, and then Uber transfer that money to Mr. Islam or whoever your Uber driver is. So they say that's a typical business relationship, okay? Because they're being paid by you. So they've got a business relationship with you. And then because they've got a business relationship with Mr. Islam, they say he's not really an employee. And he's a businessman in his own right. And this is where it just gets a bit technical, so excuse me. But there's loads of law about trying to determine whether what somebody might be calling a business relationship is really an employment relationship. So if it smells like an employment relationship, works like an employment relationship, so you know, as a businessman, I've had my own business. I've got my own business well, we sold it last year, but when I had my own business, if I didn't want to do work for somebody, I just didn't do work. If Sonia said to me, come and represent me, and I'm in business on my own, I just say, no, it's okay, Sonia, you go and do something else. You go and find somebody else. I can do that when I'm in business on my own account.
Yeah.
But if I'm employed by a firm of solicitors who expect me to pick up the work that comes in to that business, then am I really self-employed? Then can I say that I'm self-employed if they can make me do the work? That's the problem with the kind of gig economy job that I've been talking about. Because the reality is, if you turn off your Uber machine, if you say to Uber, no, it's okay, I don't want to take the job today, or I want to take a break for the next 3 hours because I'm going to go and pick up my daughter or watch Manchester United, or they're not going to send you jobs. They're going to take you off the system. Because what the law then tries to say is, well, is this really a self-employed situation where someone has the freedom to accept work or not?
Yeah.
Okay, so there are all kinds of there are a number of factors which, even if you've got the two parties calling it a self-employed relationship, the law will actually say, well, when we analyze those factors, it looks more like an employment relationship because there's too much control. There's not a real right to refuse work. You can't send someone in your place, is what is a really important factor. If you don't want to, when you were in teaching, Sister Sonia, if you didn't feel like going into work on Monday, you couldn't send Ebenezer
No,
in your place
no,
and say,
no,
oh, Ebenezer will do the job today.
No.
If you are self-employed, you would be able to send another person to carry out the service in your place. You can't do
Absolutely.
that when you're in employment. So even if the relationship is calling itself a self-employed business relationship, but you can't send somebody in your place, then the law would say that's not really self-employment. So there are all these tricks and twists and turns and little subtleties that have to be looked at in order to determine whether you're employed or self-employed, which is why I said it's more complicated than it sounds.
Yeah, absolutely. I think it's more enticing because people tend to just get the money straight when they do have contracts. You know, when you register as self-employed and then you get this contract as at when due, then you then have to pay your own tax and everything. So you get your buck coming to you. I think that is what is enticing to some people as well. But like you said, it is very, very complicated. I hope that helps.
You lose all of your rights as an employee, or what's happening there is they're trying to take away all of your rights as an employee, which costs them money because of tax, national insurance, sick pay, and what have you, the right to holiday pay, all of those things that are in the rights bit for you as an employee. And, you know, a company will try and, you know, put you on a fake self-employed contract, so they don't pay you any of those things, but then you don't have the freedom to act like a self-employed person. It's a con. It's a con. It's fraud, really, which is why the you know, political parties have talked about outlawing them.
Interesting. Thank you so much for shedding more light on that. Okay. There's more question. How many hours can a student work when they have finished their course, but yet to change visa type from tier 4 to any other visa? Is this strictly 20 hours?
So this is an immigration question.
Okay? Yeah.
Now, I'm not an immigration expert, but I do know the answer to this question. The basic requirement is for you to not exceed whatever restrictions have been put on your working hours in the right to work that you've been given in the UK. If you want to change anything, so if you want to do anything more than, if 20 hours is the restriction, if you want to work more than 20 hours, you've got to go back to the Home Office.
Oh, wow.
You've got to go back to, because if you do something which is not consistent with your immigration status, well, number one, it's a criminal offense for your employer to allow it. So your employer shouldn't be allowing it anyway. But number two, it can compromise your right to stay. So if you don't comply with whatever rules and restrictions you have in relation to working in the UK, then that's a breach of your immigration status, and in the final analysis, they can throw you out of the country. So if you want to increase your hours, if you want to change your status, if you want to do anything like that, you've got to, first of all, of course, go to your employer, and then secondly, make sure that the Home Office, that the Immigration Service is okay with it. Because if not, they can throw you out. Simple. Don't be lured into something that you might think is beneficial, where it be more hours, or staying here longer because the job is open to you for longer. Don't take the chance. Just go back to immigration. The difficulty is, the challenge is, of course, that what you'll usually be told is that you have to make a new application, and then they say you need to make your application from your country of origin if whatever status you came into the country with has now expired. Okay,
right. So it would be best for her or him to just switch first and receive the visa, the new visa and the new right, and then just progress. It would be best to wait, right?
Yeah, it would be best to make sure that they don't enter into any new arrangement that's inconsistent with the immigration status that they have, because if you do, then you're in breach of your stay, and like I say, potentially your employer is actually committing a criminal offense.
Okay, thank you so much. And someone said, can full-time contract be automatically converted to permanent employment? If so, under what circumstances?
I'm not sure I understand the question.
Even me, I think so too. Please,
so feel free to unmute, but from what I understand of the question, it seems to suggest that the contract that they're given from the beginning isn't a permanent one. So it might be for a fixed term, or it might be to cover, say, a maternity leave, or to provide work when there's a increase in the workload. So employers do sometimes then give contracts which aren't permanent. So it might be for a fixed term, or it might just be on a kind of casual basis. Come and work for us today and we'll see how it goes, but don't regard this as a permanent job. So if it's that kind of situation we're talking about, then the answer is this, okay? And again, it's just a bit technical, but bear with me. So in the UK, you can be given a temporary contract, okay?
Yeah.
And so long as you don't have any more than 4 temporary contracts which last for more than 4 years, that's perfectly legal, okay?
Okay.
But if your employer keeps giving you temporary contracts and you're there for 10 years as a result of all of those temporary contracts, then whatever it says on paper, the law actually regards you as a permanent employee, because you can't have any more than 4 years of temporary contract, okay? After 4 years, you'll regard, even if the employer doesn't want that to be the case, like I say, we have laws with rights and responsibilities. So if you've been on a temporary contract for more than 4 years, that in law actually becomes a permanent contract.
Wow. Thank you for shedding more light on that. There's a tricky one here. I said, how do you handle a situation where your employer gaslights you? And how do you handle an employer that is not inclusive? Hang on. That is not inclusive in their dealings, and you have evidence of racism.
Okay. So I didn't get the first bit. How do you handle an employer who is what to you?
Gaslighting you. So they're gaslighting the person.
All right. Okay. Yeah. So again, this is where the law comes in, because there are provisions that say an employer cannot discriminate and has to treat people equally. Also, they will probably have an equal opportunities policy. Okay. So that's the starting point, to look at those, to look at the equal opportunities policy, or dignity at work policy it will sometimes be called. Your principal first step should be to raise the issue with your manager, unless of course the person who you have the problem with is your manager. But you should raise the issue internally, because the fundamental principle in the UK is that the law wants employers and employees to try and sort things out internally. So you can raise an internal complaint through the dignity at work procedure or through a grievance procedure. And in that process, you would be expected to provide your story of what's gone on, and to provide any supporting evidence, so that it can then be investigated, so that a decision can then be made as to whether your complaint is well-founded. Okay. Now, you might say straight away, well, hold on a second, they're making a case against my employer, they're not going to find in favor of me. Well, that may be the case. It will all depend upon the investigator and the evidence and what have you. But if ultimately you don't like the decision that has been made, because it doesn't acknowledge your complaints, then you have the opportunity of bringing a claim to the employment tribunal. You don't need any length of service in order to make a discrimination claim. So even if you've been in employment for just one day, if you suffer discrimination on day one, then you can make a claim. So in short, the answer is you pursue an internal complaint under the relevant procedure. It will be dignity at work or the grievance procedure. You exhaust that process, look at what the outcome is. If you like the outcome, fine, job is done. Hopefully, matter is resolved. If you don't like the outcome, then you have the opportunity of bringing a claim.
Okay, thank you very much. I hope that helps. There's another one. He said, do I have to operate with a registered business name as self-employed, or can I be self-employed with no registered business name?
Absolutely. So if you want to offer your services to an organization, as you know, I can see Paul. So if you want to call yourself Paul Consultancy and not register as a formal business, you can do that. And if someone wants to come and pay you money and say, Paul, come and do this piece of work for me, then they'll pay you for it, and that's fine. Okay. So you don't need to have a formal business status in order to offer your services to somebody. Okay. Most people will register or should register a formal business status because there are tax advantages.
Yeah.
You know, if I'm in business and I'm driving up and down for the work that I'm doing, and I'm having to put petrol in the car, then I might want to claim that money back in tax. I might want to claim my lunch whilst I'm working back on tax. So there are advantages to registering as a business. There are disadvantages because that means more administration and a bit more control. But overall, you know, if you are going to be serious in business, then be a business, is what I would say.
Okay. Rukayat, I'm going to call you next, but just wait one sec. As a support worker, thank you so much, Abayomi. There's a question here said, as a support worker, which union is best for me to join?
It's a good question. Probably it depends what particular area you're in, whether it's the NHS, social services, but, pretty much Unison would be the most influential and the largest union for work in that sector. Unison. There'll be other unions. You can join any union you like, and a lot of unions will have kind of parts of their service that might cater for certain specialities. Unite is the biggest union in the UK. When you hear about all of these strikes going on in the UK at the moment, most of it's Unite. They're a massive union. They have public service sector sections, transport section, retail section. So probably if you want to join a big union, then Unison or Unite, probably.
Thank you so much. I think that was what I also told someone when they asked them, the one of the best union to join the last session. I'll come to that last question, but I think do you know about Walker of England? I don't even know about that one. Is that a union? I don't know about that one. There's a union called Walker of England.
I don't know. I've never heard of that union. What I will say is that be careful when you're looking at joining a trade union. The starting point for me would be that I would want the union to be associated with the Trade Union Congress. So that's the body that all serious unions join. Okay, you might have heard the TUC conference is on. So that's the kind of spokes body, the kind of corporate body for all unions. So I don't know the Union Worker of England or whatever it's called. If they're not with the TUC, then I personally wouldn't be in it. Okay. Right. But there are some good small unions, but you'd still want them affiliated to the TUC.
Okay. Right, that's a tip, everybody. Remember that. Check if they're affiliated to TUC. Thank you so much, Abayomi. Rukayat, please, can you unmute and ask your question?
Okay, thank you very much, Mr. Abayomi and Madam Sonia. Right, my question, I have two questions actually. The first one is, can having an 18-hour contract be changed to full-time? Like you already accepted the contract and everything and you want to change it to full-time. Then the second question is, what is your right as a person or an employee that has been told that, okay, you've got the job, here's the link, to do your fit to work, this and that and everything, and then you get all that done and then you hear nothing from them, and after several prompts, like there's no response, like they just black out. And I mean, it's the NHS, so.
Oh wow. Okay. Yeah, I can deal with those two questions. So can an 18-hour contract be changed? So like I said, an employment relationship is a business relationship. So when you enter into the agreement with its terms and conditions, then unless you agree to change those terms and conditions, what you entered into is what you're then entitled to expect. So if you're given an 18-hour contract, your employer can't just come along and say in 6 weeks, we now want to change it to a 35-hour contract. They'd have to seek your agreement, okay? There is a way in which they could enforce it by having a good business reason, terminating your old contract and reissuing a new one, but that's kind of a complicated process. If you want to change it, if you want to go from 18 hours to 35 hours, then you would have to do the same. You'd have to go to your employer and say, I know we agreed 18 hours, but I'd really like to increase my hours because I've now got the opportunity to do so. Can you agree to that? And if they say yes, absolutely no problem, you'll get a 35-hour contract. If they say no, then there isn't really anything that you can do to make them change their mind, because you can't serve notice on them to terminate your existing contract and force them to give you 35 hours. So really the way to change the hours in a contract is by agreement. That's the bottom line. If it suits everybody for the hours to change, then it will be easy. If it suits you, it will be very difficult. If it suits them, it will be doable, but using a process which isn't an easy process. Okay, so that's the answer to the first question. Can an 18-hour contract be changed? Basically, yes, if there's an agreement. If not, then by the ways I've described. And then you asked about what if you're offered a job, get the link, and then you hear nothing. You know, it might sound really harsh, but there's not a lot you can do, because an employer really doesn't have any obligation to you as an employee until the day your employment begins. So if your employment is due to begin on the 12th of June tomorrow, and you get an email today saying they no longer want you to start tomorrow and they don't want you to be an employee at all, your options are very limited. You don't have any right to claim unfair dismissal because you were never an employee and you've not got 2 years service. You never commenced employment, so you never you never had any rights to be paid. So therefore, when it comes to trying to sue and, you know, bring a legal case, you've not really had, technically anyway, you've not really had any losses, because you never crossed the threshold where there was a financial obligation to you. So it is really, sounds really harsh, but there's not a lot you can do if an employer decides, a potential employer decides to withdraw a job. However, you did say the magic words, it's the NHS that have done it. I do a lot of work with the NHS. They're a client of mine. The problem with the NHS is that they're useless administratively, or not very good administratively. So it wouldn't be surprised if your paper has just got lost in, you know, the administrative kind of roadblock, and it might be that they just haven't done what needs to be done to bring you on board, but they've not formally withdrawn the offer. The best thing to do is to go back to the person who confirmed that you had the job and ask them what's happening.
Yeah, personally, I would chase it up because
Sorry.
you're right. I would chase it up.
Do you mind if I come in here? I
Yes,
chased
please.
it up.
Yes.
The person who, you know, what happened was the person who did the interview was the one who called me to inform me that I have been successful. Then the HR sent me the mails and everything. Then when they went silent, I tried to message the HR. She told me she had to reach out to the department that's supposed to employ me, and when she gets a feedback from them. This I'm talking about was since January. So I
Wow.
kept going back, yes, going back and forth to both of them. And lastly, the guy who called me to inform me that I'd been successful with the interview finally pushed me back to HR, who never answers or replies their email or anything of that sort. So the last time I sent them the lady email was on I think sometime last month, and I'm just like, if I don't get anything back, I'll just count as one of my losses. But it's really unfair because I put in so much. I kind of readjusted my life, towards getting into the job fully and stuff like that. I mean, since January, it's really
So,
unfair. So I'm back on the market,
mm,
scouting and trying to find something else.
well, that sounds like a really unfortunate experience. I'm surprised because, like I say, whilst there isn't protection for people who have been offered jobs, because the NHS is a public body, their standards, their values and standards, their culture would not usually be to offer someone a job and not follow it through. I'm really surprised. So what, I mean, it may well be that too long has passed, but what I would have recommended is that you escalate the issue, and I would have recommended that you find out who so whatever area you were supposed to work in, and you can do it by Google, or just by contacting the organization, find out who the head of the directorate is for that service and tell them what's happened. Because I think that most directorate heads would say, I don't want my directorate to behave like that. So that's what I would do. So whatever service, so if it was midwifery, find out who the head of the midwifery directorate is, or if it's, osteopathy, work out who, you'd be writing probably to the medical director or something like that, but work out who it is in that senior directorate position, tell them what's happened to you and ask them, can they do something about it?
Rukaya, does that help?
Yes, it does. Thank you very much, Mr. Abayomi.
You're welcome.
Thank you.
Thank you, Abayomi. Right, do you know what? We only booked this for 1 hour, 20 minutes. Now we've exceeded 8 minutes. I know Semire, you were one of the first to arrive today. So I'm going to yield the mic to you, and then I'll take one last question, and that will be it. For those of you that came a little bit late, you can watch the replay on my YouTube and just catch up on it. Similarly, I will yield the mic to you. Can you unmute, please? Thank you.
Yeah, thank you very much, Sonia. Thank you, Mr. Bayomi, for your time. So I'll quickly run through my questions. I have a similar experience like the person who had just asked you a question. But in my own case, so I have an offer letter. Mm-hmm. It's quite a long story because the first time I went for that interview, I was taken around. The manager seemed to like me. It was like a forensic building. An organization that it's a social care building, but they deal a little bit in forensic, which is quite something that I'm skilled in. So a few days later, I got a mail that my application was not, they didn't say it wasn't successful, but they said, yeah, sorry, they were not going to continue with the application. I just let it go because, I'm used to when you're applying for a job. But then a week later, I got another email telling me this time that the manager who had interviewed me and a couple of service users had asked for me specifically, and that they are now putting me up for that offer again. But they needed to talk to me first and see if I still wanted that offer. And they explained to me that the reason why they declined the first one was because there was a mix-up in the recruitment process, and that somebody else had been signed on for that same role, which meant that my own approval came the second, so they gave it to the first person. That was why they couldn't tell me why they declined the first one. But this time that position is open again, since I said I wanted to be working more nights than day, that there was somebody who had just resigned in that office, and the manager specifically said she wanted me there. I said it was fine. They said the manager was going to call me. She did. We spoke on the phone. Immediately after the talk, I got a mail confirming that now I have the offer. And so the process started. I submitted all my documents and all of that. Now, at the DBS level, when they asked me for DBS details, I submitted the document for DBS. However, I told them that I have 2 DBS running on the updated services, which meant that they could access any of them if they wanted, but I didn't get anything. So I waited a couple of weeks, I chased, sent emails, and then somebody got in touch with me to say that the person who was doing my recruitment was on leave, but if I wanted somebody else to do it, I could give them the details. I said it was no problem. A long and short part of the story was that the day I went there, because this person resumed now, that was about 29 days or 6 weeks interval, and said I should go to the service, that they were waiting for me. I noticed discrimination. It was obvious. I wear also, at the moment, I work with another college as an emotional well-being person. So when they asked me to identify myself, what I brought out was my identity card from Bolton College. And so the person looked at it, oh, you're emotional something. Are you here for an interview? I said, no, I'm here to see the manager. And the moment they heard that I was probably, on employment list already, the only Black person, I saw the way they quietly closed the door at me and then went to get the manager. And then the manager came out to say, oh, we are sorry. Somebody should have gotten in touch with you this morning. The funding for your office is no longer forthcoming. And so therefore, we might have to decline you. The second time, I have run it through a couple of people. They'll say, yo, you have a case. But at the moment, I don't know if I do. I don't know what to do. I have the email for offer. I have, all our conversation, all my follow-up. But every time I pass in front of that office, I'm just angry because it's obvious. I mean, in fact, a few weeks after, I saw the same office. It's on advert now. They're advertising for that same role. So it's not like they've gotten what they wanted. So I don't know what to do. That's why I'm raising it here.
Okay, I understand. So ultimately, your concern is that you've been denied the opportunity of this job because of your race, which became apparent when you went to provide the documentation for the job. Is that right?
Samira, can you hear?
Oops.
Samira, you're muted. Yes, you're muted.
Yes, that's correct. Yes,
Okay.
That's correct.
So look, if you genuinely believe that and you want to challenge it, then you have two options. So firstly, you could ask them the question. Well, I know that might sound odd, but if you lay out the basis upon which you believe that discrimination has taken place, then you can give them the opportunity to reject or accept that that claim. They'll probably reject it. So that would be that would mean that you move to option 2, which would be to bring an employment tribunal claim. Discrimination cases are not easy to win. They're not. But that doesn't mean that they can't be won. So in this kind of case, what it would, if I were running this kind of case for you, what I would be asking them to do is to lay out with evidence to support it the history of those roles and the reason for them being withdrawn and when. So there should really be, you'd really expect something of a detailed timeline and some evidence from their part to support it. So maybe, an email saying that funding is being withdrawn, or that, Mr. X was appointed before you. So there should be really something by way of evidence to support what they said to you about the withdrawal of the role. So it's almost worth pursuing the case to see what it is they've got in their armor, in their locker, in their possession to support their claim that the reason why you didn't get to start that job was because of, something to do with, whether it be funding or whether it be, anything else, I think it's worth a go. I don't say that means it's a guaranteed win or anything, but I think it's worth exploring and asking questions to see what it is they've got to demonstrate that it wasn't race, because on the face of it, what you're saying is quite powerful. When I'm a face that isn't seen, I've got the job. When I'm a face that is seen, and when what I'm wearing is seen, then I haven't got the job. Those are the only two things that you can absolutely say, and then that might be enough, because technically, once you have, in an employment tribunal case, made, provided enough evidence to make it look like it's discrimination, then they've got the burden of proof to demonstrate it wasn't. And that's a very powerful toolkit in a discrimination case like this. So I would have a go. I mean, if there's if Sonia wants to share my number with you, then I can perhaps give you a bit more detail as to how to go about doing that.
Yes, please. I will appreciate that.
Okay.
Thank you very much for your time.
Okay.
Thank you so much, Abayomi. I really do appreciate it. But please, can I read one question? This is the last one.
It's okay.
Certainly the last one. Thank you so much. He said, please, sir, can you clarify on the tax advantages as a registered enterprise or self-employed? What is the tax advantage of being a self-employed? I mentioned it before that people do it because of the tax. So he's asking the tax advantage.
So like I said, I'm not a tax expert, but I have been all of these things. So I've got a sense of what the regime, the tax regime is. So if you just become self-employed and don't formally register any business, the first problem that you've got is when you take contracts, the question that we dealt with earlier as to whether or not you're really self-employed becomes an issue. But in any event, let me leave that aside for a second, because I dealt with that question earlier. But the tax regime is this: if you're just a person in business that hasn't registered a company with Companies House, then you're effectively taxed almost on pay as you earn. Okay, so your tax rate will be very much like an employee's tax rate. You'd still have to, and you'd have to fill in your own self-assessment tax return. You'd have to fill in your own self-assessment tax return. But the tax rate, like I say, is very similar to being employed, to being PAYE. Okay. So from what I can remember, I don't keep up to date with tax rate, but basically the introductory tax rate in PAYE is 20%. It's 20%, but that's for the first, I don't know, 10 or 15,000 pounds. If you're earning something more than that, then the tax rate is going to go up 23%. There's a 30% band and a 40% band. So you're taxed more or less as PAYE. Okay. The one thing that you don't have to pay though is make a national insurance contribution. So you would get effectively a tax discount because you don't have to pay national insurance. However, because you're on your own, it would be sensible to, because national insurance is where your pension and what have you is built up. That's what national insurance is. So you'd then be advised to make your own arrangements for pensions and insurances and what have you. So you still might be on around the same level of deduction. The other option that you have is to set yourself up as a limited company. So to become Ruqyat Nursing Services Limited or Business Service Limited. So to register yourself with Companies House. Now, when you set up as a limited company, you're not taxed as an individual. You're effectively taxed as a corporation. So you're not paying income tax, you're paying corporation tax. And corporation tax is lower than income tax. It's lower than income tax. That 20% level will take you to about, I can't remember now, it's so long since, but it might be around £80,000 of profit. So for the first £80,000 you earn, your tax rate is only 20%. Whereas in employment, for income tax, the first 15 or £20,000 you earn is covered by the 20% rate. So you're into higher rates of tax much sooner on income tax. On corporation tax, no, there's a 20% limit for, like I say, it might even be up to about 100,000 you can earn. Companies pay less tax than individuals. Morally, you might question that, but that's how it works. Okay, so you have a cheaper tax liability for if you set yourself up as a limited company. There are also more tax clawbacks that you can make. So, you know, you can have, you know, tax rebate for somebody else doing your work. You can have tax rebates for reinvesting profits into the business. There are all kind of things that you can do when you're a limited company and setting yourself up as a corporate entity. You've got more options. If you, that's what smart people do, you see, and they don't expect us to be smart, really. It just becomes a, you probably would need some advice from an accountant or some kind of service, which would be a cost, but it would be worth it if it could save you that kind of tax and minimize your liabilities by making tax reclaims. Okay.
Thank you so much, Mr. Abayomi. So please just drop in the chat session some appreciation. Thank you so much. We've taken 40 minutes extra of your time. We really do appreciate this, Mr. Abayomi. I hear everyone saying thank you very much. I really appreciate this. I'll speak to Semire later. I dropped my number there so I can speak to her, and then I'll pass your number to her if she still want to pursue this, because she did send me a message that the job is being re-advertised. Yeah. And yet it's just a bit funny. I'm not quite sure what to make of that. Yeah. I hope she chases it up. So thank you so much. If anybody wants to watch this, I've dropped the link in the chat. If you can't find it, just look for Sonia on YouTube to be able to catch up and share with people that might find this beneficial. I would like to say thank you so much.
You're welcome.
I've learned a lot today, and I hope you find value from this. And I hope this will help someone someday. Thank you so much, Mr. Abayomi. Enjoy the rest of your evening.
Well, you're welcome. Look, if there's anything that I can, do to help again, just say, it doesn't have to be the last time that, we congregate. So if there's anything that I can usefully do, then I'd be happy to help. Okay.
Okay. Thank you so much. All right. Enjoy the rest of your evening. Bye, everyone.
Bye. Thank you. Pleasure meeting you all. Bye.